Morning, everybody, and welcome to today's masterclass. For those who don't know me, my name is Jessica Blumenthal, and I am a director in the Banking and Finance Department sitting in Cape Town. This masterclass is one of a series of masterclasses that we've been presenting through April and now through May. Each of our masterclasses is accredited for continuous professional development. So if you are in the financial services sector and need to work up or work in your CPD hours before the cycle ends at the end of May, then these masterclasses have been accredited. And to the extent that you remain online for the duration of the masterclass, you will be able to get a certificate confirming your attendance at the end of the session from our team. This year, we have focused our masterclasses on topics that we think are emerging as opportunities or risks under the banner of ESG. And today we are focusing on a governance topic, very important topic around contracting with organs of state. And we're very lucky to be joined by two executives from our public law department, Pippa Reyburn and Yana van Leeve. Thank you to both of you for joining us today and for sharing your expertise with us. Just a reminder to all participants, you are able to ask questions during the session. You can do so by adding them in the Q&A block that you see at the bottom of your screen. If Yana and Pippa don't have time to get to your questions during the session, which is a real risk because I know that they've got a great presentation to share with you, then they will be able to contact you directly afterwards and address your question. And that's why it's quite important that you use the Q&A block and not the chat, because we're then able to see your details and they can correspond with you. So please do share your questions with them. Then again, just a reminder that if you do want a CPD certificate, you do have to stay on for the full hour. We unfortunately cannot issue certificates to people who've only been on for part of the presentation. So please do bear that in mind. And without any further time wastage from me, I'm going to hand over to Pippa and let her kick off today's discussion. Thank you, Pippa. Pippa, I think you're still on mute.
Thanks very much, Jess, and morning, everyone. So I'm just going to take you through our agenda, and then Yana will do her portion of the presentation, and then I'll continue with the second half. So the topics that we want to cover today, we're first going to look at what is an organ of state and go through the various categories of organs of state. Then we're going to talk about different types of contracting between the private sector and organs of state. And then we're going to focus on two types. The first one is contracts for goods and services, which is also known as procurement or supply chain management. And then Yana will finish off by talking about the consequences of an invalid contract. Then I'll start my section with talking about a second category of contracts, which are borrowing transactions. And then I'll also go through some of the steps that can be taken to reduce the risk of invalidity. And then we'll finish off with a short section on recent or latest regulatory developments that may be of interest. So now I'll hand over to Yana. Thank you.
Thanks, Pippa. Afternoon, morning, everyone. So really the first conceptual thing to unpack is what is an organ of state? What are we talking about when we use the words organ of state? The answer to that question lies in the Constitution, and the Constitution has a fairly broad definition of organ of state. In the first instance, it defines it as any department of state or administration in the national, provincial, local sphere of government. And instinctively, that's very, very easy to understand because that's who we commonly associate as being part of the organs of state, people who are part of the executive branch of government, who are part of the legislative branch of government. But, you know, in an era of privatization of public services and utilities, and where the private sector, as we all know, plays a very significant role in the delivery of services and in the performance of functions for and on behalf of the state that traditionally many years ago would have been performed by government, the Constitution adopts quite a wide definition. And our courts, as I'll explain, are not afraid to ensure that private entities performing functions on behalf of the state also acquire the classification of organ of state. So to make that quite clear, Section 139B of the Constitution also provides this wide component of the definition, which is simply that any functionary or institution exercising a power or function in terms of a constitution or in terms of legislation is also an organ of state. And so, as you can see there, the concept is quite wide. And there are really two policy reasons for this. The first is in the context of the relationship between the public and private sector, where the private sector performs functions for and on behalf of the state. The state can't be released from its human rights and rule of law obligations simply because it's delegating its functions to another entity. Those accountability requirements don't fall away because a PTY Limited is providing those services. And secondly, administrative action, which is essentially the performance of public powers and functions in terms of legislation and typically associated with the way the bureaucracy behaves. Administrative action and the law that governs it is really the interface that we have as citizens, as people, and with the state, where our day-to-day lives are profoundly affected by the way those who hold power over our lives exercise that power. So to touch on this more controversial area, which is, well, what constitutes a public power function? And the sort of simple answer is, unfortunately, there isn't a bright line that tells us when something is exactly a public power function. But there are questions that we can ask to determine whether something is public power function. And these are really developed in the case law. And through cases. There's no legislation that's going to tell you every instance of public powers or functions. And so over the last many years, our courts have developed kind of useful questions or indicators. And these are things like whether the power applies generally to the public or a part of it, whether the power is coercive, whether it's exercised in a monopolistic manner, whether it's connected to a legislative purpose, whether it's aimed at benefiting the public or performed for the interest of the public rather than for profit or private gain, and whether there are penalties imposed or whether, something like accountability should be warranted in the circumstances. So I accept these factors are quite abstract, so we'll look a bit at some specific examples. I'm unfortunately not going to be able to touch on all of them, but I'll take you through a few, just a selection of these examples. So if you take something like regulating the micro-lending industry. So the micro-lenders are lending small amounts of money, typically to people who don't easily access finance or loans. So in 2006, the courts had to analyze the status of rules imposed by a privately established non-profit association called the Microfinance Regulatory Council. And in doing that analysis, the courts looked at the function that the council was performing. For instance, it could establish generally applicable rules for the industry. It was also at the time regulating the application of a ministerial exemption under the Usury Act, which regulates loans, and the minister had invoked an exemption for the micro-lending industry, and the council was effectively regulating that entire application of that for the minister. And this kind of small aspects of that was they were determining who could qualify the exemption. Micro-lenders had to be registered with the council. They could compel compliance with the minister's exemption notice. And they were also setting the criteria for accreditation as a micro-lender. And in this sense, they were controlling the industry and they were determining who could access the industry. And in some senses, they were kind of gatekeeping. And this idea of gatekeeping and control, the court said, well, this looks to us like an organ of state. And this idea was also extended in the payment of social grants on behalf of the South African Social Security Agency, when the Constitutional Court said that Cash Paymaster Services, who was providing those payment services, was an organ of state. And there, other things that the court looked at was the dependency of grant beneficiaries on Cash Paymaster Services for access to their social grants. They took a large chunk of the consideration was in relation to the role that Cash Paymaster Services was playing in realizing the constitutional right to social security. And in the context, it was also the sole provider of the payment mechanism. Another more kind of benign or simple example is also in the supply, installation, and maintaining of prepaid meters. And this example arose back in 2012 when City Power was contracting with Greenpal for these functions, and it decided that it no longer wanted to be part of that contract. It alleged on a rather, spurious basis that Greenpal had submitted fraudulent tax certificates. That was never analyzed or confirmed. But in the course of the negotiations of the termination of that contract between City Power and Greenpal, the parties that had agreed that since there was no new service provider that had been appointed at the time, there would be a full handover of the entire infrastructure, software, and database relating to the project from Greenpal to City Power, with the effect that City Power in the interim, so i.e. pending the appointment of a new service provider, City Power would be conducting the business until the service provider was appointed. And in the handover process, City Power was, of course, happy to take over all of the infrastructure and the software and the databases. But City Power said, well, we can't take your employees. We're an organ of state. We can only appoint employees under the Municipal Finance Management Act and under the Municipal Systems Act. And the court said, no, you can't. Just because you contracted your services to a third party for and on behalf, you don't escape accountability. You must take transfer of those employees. So the implication there is that when organ of state like a municipality enters into an outsourcing agreement for a defined period, it will run the risk that when the contract terminates, that the municipality is required to assume the obligation of financing the ongoing employment contracts of those who had been previously employed at the initial service provider, and that the consequences of transfer under 197 of the LRA should be dealt with in the contract. So you can see it cuts both ways, really, the classification of an organ of state. And then there are other examples of performing public powers and functions like operating a prison or cancelling a contract concluded pursuant to a tender, which is also examples of exercising a public power function. So what are the consequences of this classification? Organs of state attract a much higher level of scrutiny and accountability. And so the classification or the conclusion that a private entity is an organ of state when performing a public function or power it can be quite far-reaching. And we can look to those examples in how the Constitution ascribes certain additional layers of accountability. So, for example, the Constitution specifically says the National Assembly maintains oversight over all organs of state. The National Treasury can stop the transfer of funds to an organ of state if it commits persistent and material breaches of its instructions that it issues from time to time in terms of legislation. The Promotion of Access to Information Act expressly provides that an entity can be public for the performance of certain functions. And in that context, a requester for information would be entitled to the information as of right. And you know that if it requests information from a private body, it has to link the exercise, link its request to the exercise of the protection of an existing constitutional right. So there will be wider requirements of disclosure in that context. The Public Services Act uses the definition of an organ of state to determine when its provisions apply. So again, they're adopting the more wider definition. And if you think back to the Grimpol example that I gave you now, you can have a situation where a PTY Limited, a private entity, when it's performing a public power function, may acquire additional employment consequences because its employees are providing a service in that particular context. Similarly, the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act, PI, imposes different procedures for eviction at the instance of the state, and certainly different obligations in relation to alternative housing and in relation to public participation requirements are run differently. The Protection of Personal Information Act and the Prevention of Combating of Corrupt Activities Act all use this wider definition. There are also financial consequences. The most obvious and stark example is in the All Pay matter, which was around the payment of social grants. There are really 2 points there. The one was that Cash Pay Master Services, the Constitutional Court ordered, had to continue running the service, providing the service, the payment mechanisms to grant beneficiaries, notwithstanding that the contract was declared illegal. So they had to continue doing the services. But then most importantly, which is a little bit more of general application, is that when a private body is performing a public power and function, so i.e. it is cloaked with this classification of an organ of state, its operational and financial information is subject to public scrutiny for those purposes. So the public parliament has the right to see exactly what the financials are, what the operations are in relation to the performance of that public power and function. And then lastly is judicial review. Our courts, and this is really a feature of our constitutional system, which effectively is that all public powers and functions can be challenged through our courts, and on that basis must be justifiable. So we've got, we're far from this situation in which public entities or public powers or politicians, can say what they want to without being checked through the courts. There has to be a proper process, and courts can scrutinize it. So those are some of the general principles. And now we're going to look more deeper into contracting with organs of state. Typically there are 4 classic ways in which the state will contract with the private sector. As Pippa mentioned, we're only focusing on 2. We're focusing on contracts for goods and services, or procurement, which I'm going to take you through at a high level now, and borrowing contracts. But there are also disposal contracts and concession agreements. And each of these kinds of contracts are regulated differently. So procurement isn't the same as borrowing money. And although disposals are typically conducted through a competitive process, there will be additional legislation depending on the nature of the asset or the right, or whether it's a lease or the disposal of immovable property. So public procurement. And again, all things start with the Constitution. So what is it? Procurement is regulated in Section 217 of the Constitution. And what it does is 2 things really. The first is that it prescribes that organs of state, whenever they're contracting for goods or services, must do so in accordance with a specific kind of system. That system must be one that is fair, transparent, competitive, and cost-effective. And those are key features of any procurement system. But then also recognizing the context of South Africa and our transformative goals of the Constitution. Public organs of state are specifically authorized to create policy that can enable categories of preference in the awarding of government contracts, to protect and advance persons or category of persons that have been disadvantaged by unfair discrimination. And that has been given effect to through the Preferential Procurement Framework Act, and is a guideline through which organs of state or public entities can adopt policies. So obviously that's very high level, the constitutional provisions. So we have a raft of legislation that gives effect to Section 217. So I'm just going to list the most important ones here for you. The first is the Public Finance Management Act, which applies to departments and public entities in the national and provincial sphere of government. Allied to those are the Treasury regulations. And in addition are notices that Treasury issues from time to time in terms of the PFMA. And unfortunately, they don't gazette it. You have to keep up to date with the National Treasury's website to find out what these rules are and how they change. And they're very important to keep abreast of because they influence directly the processes that organs of state and public entities must follow in the procurement, to the extent that they make issue notices and instructions regarding procurement. The Municipal Finance Management Act applies more locally to local government, and there are regulations attached to the Act which prescribe the procurement processes. The triple PFA, which I've just mentioned now. Other pieces on the next slide. The Promotion of Administrative Justice Act, which regulates the process from a fairness perspective that must be followed. And we'll talk a little bit about that when we deal with the invalidity of government contracts. The prevention, again, comes up, the Prevention of Combating of Corrupt Practices Act, the Broad-Based Black Economic Empowerment Act, and then supply chain management policies. So these are policies that are applicable to specific entities, and included in the supply chain management policy will be the delegations of a policy, authority policy, or the risk and, the significance and materiality framework. If you ask me, what is the procurement policy of entity X, public entity X, one's got to read the specific policy framework or the specific policy in the context of all of the applicable legislation to really get a sense of what the procurement practice and framework is for that particular government department or public entity. So in the world in which a contract is awarded and there's a tender is awarded, and a contract is in place, another key issue is in how to read and interpret those contracts. Now, the interpretation of contracts between public bodies and private bodies is a little bit more complex because public bodies exercise powers and functions, and they enter into contracts through an authorizing legislative framework that really influences what the public body can do and how it can do it if called upon to do various things under the contract, like it must vary the terms of the contract or extend the terms of the contract or what have you. So typically in the interpretation of a contract for goods and services, one would look to the contract itself, but you also look at the tender documents, so i.e. the documents that led to the conclusion of the contracts. And then in addition, you would have regard to the legislation that I've just taken you through. So really in the context of public and private contract, one can't really ignore public law principles entirely. And initially, the court took quite an orthodox private law view of this. They said that once the contract was concluded pursuant to a tender process, the private law applied. And the private law applied in the context of cancellation of the contract or in the context, and we've seen very, very late up to 2015 and so on, and even beyond that, even in price negotiations, there's been this view that that it's regulated by private law, so i.e. simply between agreement between the parties. But actually, what we've also seen over the last 15 years is our courts have developed a much more nuanced approach to contracts that are concluded between a public entity and a private entity. And what it effectively has been asking is, can the state ever act in a private capacity, given its vast economic power, given its inevitable duty to act lawfully? It must always act in the public interest, and it's always engaging in public functions. And there is, of course, a heightened standard of scrutiny. And in the context of those long, decade and a half's worth of court decisions, the conclusion really is that one can't escape the principles of administrative justice in the contractual setting. But again, it's not a bright line test for determining when the public law principles apply, which principles apply, and how they should be applied. So accepting that it's not always clear, courts have given us some indications of when one would look specifically to public law principles. And that's really, once again, when there's coercive state power at play, where the public interest is affected in the exercise of the contractual right and the terms of the contract itself. So examples would be, is extending the lease agreement. What kind of process should be applied there in that circumstance? If a BE status of a bidder changes after the contract's concluded, should public law principles apply? Do they, and how do they? What if the bidder or the contract provides for a specific material or mechanical item, but that's no longer available and something else needs to be provided? What about maintenance issues? What happens when the private party can't perform? What is the range for price negotiations? All of those kinds of examples, it's not clear that, not that it's not clear, it is clear that one can't purely adopt a private law lens. It's not up to simply the state and the private party to decide what will work for them. There has to be a wider public process at play. The next slide, so that's really the context. So what happens then if there's an invalidity? The point here is, I think we're on the next slide, which is consequences. Yes. The point here is simply that public procurement decisions are administrative action. And the general or even the trite rule is that decisions, the decision to award the contract and the contract itself will continue to have legal consequences until it's set aside in judicial review proceedings, usually under the Promotion of Administrative Justice Act, which I mentioned when I referred you to the key pieces of legislation that apply to government contracts. And the basis for challenging the administrative decision in review proceedings, or the reason why you would, isn't because the administrator could have made a different decision, or because the administrator could have made a better decision, but rather because there's some problem in the process that led to that decision. And these problems could turn on the negligence of the public entity, or because perhaps there was some malfeasance. So, for example, you can have a situation where the delegations of authority policy wasn't properly applied, or the wrong person within the public entity approved the transaction, or there was no approval at all, or there's an express allegation of corruption, or there was undue influence. Those would be the kinds of reasons one could challenge an administrative decision or decision to award a contract. And the basic rule really is that administrative decisions must be challenged within 180 days. And depending on who you act for or which side of the facts you land on, you can argue that a person has 6 months to challenge a decision, or some will argue that the decision must be challenged as soon as possible within the time period. But we would say really that because of the enormous complexity involved in some of government contracts, it's prudent and better for the person who challenges this decision to act expeditiously. And there's also, it's practically important because often the delay affects one's chances of getting an effective remedy, in the sense that the contract is awarded and the state proceeds with that contract, particularly if there's no interdict to stop the implementation of that contract. And sometimes that contract can run for a long time, and that undeserving successful bidder isn't removed and remains in that position. The other reason why it's important to act prudently and quickly as quickly as possible is that after 180 days, a court can refuse to entertain the application for review unless it grants condonation. So condonation is essentially saying, I'm sorry I'm late, but please consider why I'm coming. And again, depending on who you are or whether you're a private entity or a public entity, the expectation for a full and frank disclosure for the reasons of the delay are very important. And if it's a public entity, the expectations of a full accounting is even higher. Because courts say, have a much higher standard of expectation for the behavior of the state, particularly when alleging that there's a problem in the process which will turn on the legality of that decision. Typically, courts have quite a generous and wide remedial power to make a just and equitable order when they say that a process there's an invalidity in the process. And this means that there's a kind of glass wall between the invalidity of the decisions and the consequences that flow from the decisions. And that's really, so courts have quite a wide remedial power. And the key requirement really for any administrative law remedy is that it must be fair to those affected by its decision, and it has to vindicate the right that's been violated, the so-called corrective principle. So in other words, it must do right by the successful party that's aggrieved by the decision, and it must correct the defect in the process so that so it restores a tolerable situation in the face of the illegality. And some typical or basic remedies that the court will grant is they can remit the matter back to the decision maker, so they can send it back to the tender board or the decision making or to the public, the board of whichever the functionary was, whether it's the board of directors of a public entity or the MEC or the HOD, whoever that might be. It can substitute the decision of the administrator, so it can make its decision the standing one, or it can grant compensation in circumstances where remittal and substitution are not available. The substitution remedy, though, and the compensation remedy are both regarded as exceptional remedies, but for different reasons. Substitution is an exceptional remedy, and the courts are quite reluctant to grant substitution because often procurement is policy laden or highly technical, and judges are not engineers, they're not accountants, and so it's really when there's no dispute, or it's what they say a foregone conclusion, that they would be willing to replace the decision of the administrator with their own. And compensation is considered exceptional because it's available if remittal, so i.e. returning it back to the decision maker, isn't available, and substitution isn't appropriate. But in addition to those three remedies, as I said, the courts have such wide powers under the Constitution to grant a just and equitable remedy, that they can do things like suspend the operation of the declaration of invalidity. So i.e. they say, this decision is invalid, but I'm going to suspend my decision, the operation of this decision, for a certain time until X happens or what have you. Or they can refuse to set aside the invalid award tender that's been awarded. Or they can leave intact the parties' rights under the agreement, even though that agreement is declared invalid. And orders of those kinds, where the court exercises its jurisdiction to suspend the declaration or refuses to set aside the contract, it's often justified when the innocent party relies on the validity of the contract and the prejudice that party and the general public will suffer. So you'll recall all pay, where if the court had didn't suspend the operation of its declaration of invalidity or require all pay to continue to provide the service, then a grant, between 15 and 17 million grant beneficiaries would have been seriously prejudiced. Or the hospital has already been built, for example. Those are kind of practical examples where the court will use its wide powers to give quite pragmatic solutions to the parties. But there are also circumstances, and this arises particularly for lenders, where third parties are innocent and they're not part of the tender process. They don't know anything about the invalidity of the contract. They enter into further agreements. Insurance is applied for or taken out. Rights in land are acquired, and so on. And in those kinds of circumstances, although innocent parties are not entitled to benefit from an unlawful contract, they're not expected to suffer losses. So courts are willing to make innocent parties whole by compensating them for their expenses. However, they are prepared to take one step further, where third parties are diligent and they've taken positive steps, active steps to seek assurances from organs of state about the contractual rights and the regularity of their agreements. And in those circumstances, we have seen courts saying that those parties are entitled to hold on to their profits derived from an unlawful agreement. So that's really the high level of contracting for goods and services, and it represents some of the key principles and the pieces of legislation applicable to procurement. And my colleague Pippa is now going to take you through borrowing contracts. Thanks very much.
Thanks, Yana. So as Yana mentioned, we're going to focus on the two types of contracts that are, I suppose, most commonly of interest to an audience like this. And the second one is borrowing. And by that, I mean lending by organs of state. So borrowing, not lending by organs of state. So before I go into the sort of key features of borrowing transactions or the regulatory framework for those, I just want to talk about the various categories of organs of state that are impacted by borrowing rules. And there are four key categories. The first one is national government departments. And I'm not going to talk in detail about that. Essentially, the national government borrows through the Minister of Finance, who borrows on behalf of the state. So individual government departments in the national sphere don't go out and conclude their own borrowing contracts for purposes of fulfilling their individual mandates. The second category is provincial government departments, and those are regulated differently also by the PFMA, but the PFMA then would refer you to the Borrowing Powers of Provincial Governments Act, and that sets out a framework for provincial borrowing, which is quite onerous. It provides for a number of constraints on provincial government's ability to borrow money, and essentially submits provincial government to a national sort of supervisory role. So there's a loan coordinating committee that's established, which the members of which are the individual MECs for finance in each province and the Minister of Finance. And they do a sort of annual assessment of the needs of provincial governments to borrow. And then there's a kind of agreement or sort of collective decision made about the extent to which individual provincial governments can borrow on an annual basis. So I'm not going to go into either of those. I'm going to focus on the bottom two categories. The first one is national and provincial public entities. So those are separate juristic persons established either in the national or the provincial sphere, and I'll talk about that in more detail. And then the other category is municipalities, which are regulated by the MFMA and have separate borrowing powers. So each of these categories is regulated differently. similar to the categories of contracting, and we'll talk about those two in a bit more detail. So public entities are also known as SOEs or SOCs, although not all of them are companies. A lot of them are statutory corporations. But in terms of the PFMA, importantly, it kind of establishes a default of no borrowing, or no authority to borrow, unless it's provided for in the PFMA and in other legislation which is not in conflict with the PFMA. So there's a kind of cumulative requirement for authority to borrow. So an individual public entity, say Eskom or Transnet, can only borrow if it has borrowing powers both under the PFMA and under other legislation. And that other legislation could be the Companies Act. So in the case of SOCs, they would have a sort of automatic authority to borrow by virtue of being established as a company under the Companies Act. But in many cases, individual SOEs or SOCs are established by a specific piece of legislation that sets out their mandate, their structure, and constraints on their authority. And that legislation could also regulate their ability to borrow. So when you're dealing with an organ of state that wants to borrow money, you have to have regard to both the legislation in terms of which it's established, and in some cases that's the Companies Act and a separate piece of establishing legislation for that entity specifically, and then the PFMA. So I'm just going to take you through the PFMA sort of general principles on these various categories of public entities. So the PFMA divides public entities into essentially 5 categories. The first one is Schedule 2 public entities, which you may know about, and those are the major public entities. So that's Eskom, Transnet, AXA, SAA, and various others. And those ones have, those are the sort of big public entities that have a commercial mandate of some sort, and they have essentially unlimited borrowing powers, at least in local currency. So they don't need external approvals from ministers, but they have to borrow through approval by their boards of directors, which are known for PFMA purposes as the accounting authority. And then subsidiaries of those Schedule 2s under the PFMA are categorized in the same schedule. So even if it's a tiny subsidiary of a major public entity, it has all the same powers and duties as the holding company itself. So all of their subsidiaries would have the same authority to borrow as the holding company. Importantly, though, the board or accounting authority can only delegate its borrowing powers with the prior written consent of the Minister of Finance. So if you're dealing with an SOE, you either need to get a board resolution approving borrowing, or you need to get the evidence supporting an authority to delegate given by the Minister of Finance, and then the actual delegation by the board to usually the CFO or the CEO or another sort of subcommittee of the board within the institution. And it's important to follow each leg of that chain of authority in order to establish the power to borrow or to enter into borrowing contracts. The other entities that have some borrowing powers, although again subject to ministerial approval, are the schedule, what they call 3Bs and 3Ds. Those are the national and provincial government business enterprises. So those are public entities that are established in order to conduct activities that may generate revenue or that are intended to generate revenue. So they, at least notionally, shouldn't be wholly or substantially dependent on the state for grant funding. So they're meant to earn their own income, and those ones there's a sort of default prohibition on borrowing unless they're authorized to do so by the Minister of Finance by notice in the Gazette. So even if their establishment legislation authorizes them to borrow, they have to get this kind of double authority again. And you can check that authority because it has to be published by the Minister of Finance in the Government Gazette. So in the event that the Minister of Finance does authorize one of those bodies to borrow, then they have to borrow through their accounting authority, so the Board of Directors, at national level. And if they're at provincial level, they can borrow through the MEC for finance in the province. So you can see that these various categories are treated quite differently depending on their level of autonomy, their ability to earn income to repay their debts, and taking into account the sort of financial consequences for the state if there were to be sort of unconstrained borrowing by all of these entities. So I've got there that examples of national government business enterprises, so those are Schedule 3Bs, that have been authorized to borrow are water boards and PRASA. So water boards have a sort of running authority to borrow that gets reviewed every year or two and published in the Gazette again. So their borrowing limits are prescribed in the notice in the Gazette from time to time. PRASA, which was meant to be income generating, but I think hasn't really turned out like that. But at the point where it entered into a huge contract to buy trains, it was a 50 billion rand contract, the Minister of Finance authorized it to borrow funds in order to conclude that transaction. And then from time to time, there'll be another government business enterprise that's authorized to borrow, and they would have to make application to the minister for that authorization and sort of submit their business case in order to try and persuade the minister that they should be given that authority, even if for a temporary period. Then the Schedule 3A public entities, so those are at national level, but substantially or wholly dependent on the state. There's a general prohibition against borrowing, and the PFMA says that they can only borrow through the Minister of Finance. So the language of borrowing through the minister has always been a little bit contested as to exactly what that means, whether that means the minister borrows on your behalf or whether it means you can borrow with the permission of the minister. And there's a legitimate debate about that, which I won't go into now unless it's necessary. It's important to note that the Minister of Finance, in terms of the PFMA, may prescribe limits for borrowing in foreign currencies. This was also a little bit debatable because the term prescribe is defined in the PFMA to mean prescribed by regulation, but the Minister has never issued regulations prescribing foreign borrowing limits. But the practice has developed over time of issuing letters to each of the major public entities that have authority to borrow on a more or less annual basis or from time to time, prescribing by letter a limit on their foreign borrowing authority. And most of them, or all of them as far as I know, consider themselves to be bound by those letters as being their foreign borrowing limits, even though they're not prescribed by regulation. Section 68 of the PFMA is important because it essentially transfers the risk of non-compliance with all of these borrowing authority provisions to the private sector, or to the lenders, in the sense that it says that borrowing and related transactions concluded in contravention of Section 66, which is the one regulating borrowing powers, those contracts are not binding on the state. So it's kind of a lender risk compliance with all of these provisions. And then I just want to talk very briefly about guarantees, indemnities, and security, because those are also activities that are regulated in terms of the PFMA in the same provision as borrowing, and the authority to issue a guarantee indemnity security is not identical to the borrowing powers, but it's provided for in the same sort of regime. So government guarantees must be issued by the responsible cabinet member. So if you're dealing with Transnet, that would be the Minister of Public Enterprises. You have to, if you're dealing with the Land Bank, it would be the Minister of Finance, etc. So you have to work out who the appropriate line minister is. And then that cabinet member has to act in concurrence with the Minister of Finance. So there's a kind of double approval requirement if you need a government guarantee for the obligations of, for example, a public entity. And then Section 66 provides that public entities themselves, which have the authority to borrow, so those are the Schedule 2s, also have the authority to issue guarantees, indemnities, and security through their boards. And then just lastly to mention, there's this concept of another future financial commitment, which is regulated along with borrowing and indemnity, security, etc. And there was considerable debate for the first kind of 15 or 20 years of the PFMA's operation about what the meaning of this term was. And then finally in 2019, there was a Constitutional Court decision which confirmed that future financial commitments are not any future financial commitments concluded or entered into by an organ of state. They're future financial commitments of a type that's similar to borrowing guarantees and security. And the court also importantly confirmed that a contract procured through the institution's supply chain management system, which Yana dealt with in detail, wouldn't be bound by this provision. So the authority to enter into a procurement contract is not regulated by Section 66, which deals with borrowing, etc. So that was quite a useful clarification by the court. And then just to mention that government doesn't issue guarantees for municipal debt obligations, so they're kind of on their own. Moving along to municipal borrowing. So that's regulated by the MFMA, and it provides for municipalities to have both short-term and long-term borrowing powers under this Act. And it constrains municipalities to the purposes and the procedures in terms of which they can borrow on both a short-term and a long-term basis. So short-term is within a financial year to bridge shortfalls or fund capital requirements, and must be done in the realistic expectation of either income through the provision of services or allocations by the state in order to be able to repay debt within that financial year. And then long-term borrowing is only for specified purposes. So municipalities can't borrow on a long-term basis just to cover their operational expenditure or to cover anticipated shortfalls in payment for services or things like that. They can only borrow for capital expenditure on property, plant, or equipment, or refinancing of other long-term debt. So, so you have to, if you're lending to municipalities, inquire into the purpose of the loan and make sure that the authorizations or resolutions of council that you obtain as support for their authority to borrow provide for the borrowing to be in respect of these specific purposes. There's a total prohibition on municipalities borrowing in foreign currency or borrowing in circumstances where the debt is indexed to or affected by fluctuations in the value of the rand against any other currencies. So they can't either directly or indirectly borrow in foreign currencies. And then just to note that there is a specific procedure in the MFMA that has to be followed by a municipality before it can finally conclude a borrowing contract. And that procedure involves both the approval of the municipal council, and there's kind of specified information that must be put before the council before it can make a decision to approve borrowing. And then where there's long-term debt involved, there also has to be a public participation process. So the municipality has to put out to the public information about the proposed borrowing and give the public an opportunity to make representations or comment on that borrowing before it makes a final decision, and there are time periods that apply. And then just to note that municipalities have fairly broad powers to issue security for their obligations. So I'm not going to go into those in detail. Okay, so just to talk a little bit about, I think summing up, I think the sort of takeaway from both of our submissions is that government contracting is risky, and there's the risk of a contract being set aside is real, and that can happen at the instance of a competitor. It can happen at the instance of the institution itself. So there are a number of court cases where there's been a change of regime or a change of heart on the part of the institution, and they've gone to court to set their own contracts aside, even though they supported them a year or two earlier. And contracts can be set aside even if the counterparty, whether it be a lender or a service provider, is innocent. Contracts can be set aside even where the contracting counterparty had no knowledge or couldn't be expected to have knowledge of the defects in the process or the fraud or corruption that took place. So all of these are risks that do exist. And importantly also, state conduct, state decisions can't be ratified after the event. So if a board of a public entity, or say an official in a public entity, makes a decision to enter into a borrowing contract and didn't have authority to do that at the time, the board of directors can't ratify that decision lawfully. They had to actually have the authority at the time in order for the contract to be lawful. It also means that there's a risk that warranties and representations which are given in a contract will be worthless if the contract is set aside by a court. So all of those are risks, and there's no real getting around them, but they can be mitigated. And by proper due diligence. And so we always recommend that counterparties do proper due diligence on the legal authority, and we've talked about the ways in which that's verified. Proper delegation of authority where that's applicable. Any external statutory approvals having been sought and obtained, and those could be in terms of the PFMA or in terms of other legislation regulating the institution. And where there's a contract for goods or services, that there was a constitutionally compliant tender process or proper deviation from the requirement of a tender process that was followed. So you can do a due diligence in order to get the assurance that there aren't any red flags, even if you can't get a definitive conclusion on lawfulness. And as Yana mentioned, the courts have quite wide discretionary powers in relation to remediation. So even where a contract is set aside, if you've done everything possible to mitigate the risk of unlawfulness and to do the due diligence, your chances of getting a just and equitable remedy that protects your rights are considerably enhanced. So this is just a slide, a sort of visual of the kinds of checklist items you would look at when you're dealing with organs of state, and when you're contracting. So when you're doing your due diligence, you would look at who am I dealing with? Is it a national, provincial, or local government organ of state? Which legislation regulates it? Is it the PFMA, the MFMA, their establishment legislation? Is the PPPFA involved? So that would be where it's a contract for goods or services. Are there national treasury regulations and instructions that apply? Then look at the bid documents themselves, whether the contract that you're potentially lending in respect of or contracting into was met the requirements of the bid documents. Did the institution follow its own supply chain management policy in relation to the procurement method and the evaluation process? does the letter of award reflect what you bid and what was put out to tender? Are any conditions that were imposed in terms of the letter of award fulfilled? And then finally, does the contract reflect what was put out to tender and what was bid? And those are all just sort of basic checks that you can do, even if you don't have access to the internal documents of the institution, their bid evaluation reports, etc. Okay, I'm going to end off with one slide on the recent or latest regulatory developments, which sort of changed the procurement landscape a little bit. So last year, there was what's called National Treasury Instruction 3 of 2021 was issued. That allows institutions, so that's government departments and public entities, to make their own decisions on procurement deviations and contract variations. For about 5 years or maybe more before that, there was an instruction that was put in place in 2016 as a sort of response to state capture that required those organs of state to go and get National Treasury approval before it approved a procurement deviation. So that would be a contract that is awarded without a tender process. And there may be circumstances where that's lawful, but until the 1st of April last year, an institution had to go and get Treasury approval to get permission to deviate. But from 1 April 2022, they can approve that themselves. And similarly with contract variations, before that they had to go to National Treasury to get approval. Now they can approve those themselves. So it doesn't mean that every time they approve a deviation or a variation, those will be lawful, but it does speed up the decision-making process considerably, and it allows them to take into account the sort of detailed circumstances that Treasury wasn't always aware of when it was faced with those applications. Another recent development, which warrants a discussion on its own, but I won't go into that, is the new preferential procurement regulations. So those came into effect in January 2023. They replaced the 2017 regulations, and those 2017 regulations were the ones which allocated preferential procurement points to the BEE status of a bidder. And what the 2023 regulations have done is to open up the way in which those preference points can be allocated on a tender by tender basis. So each institution can now decide for itself how it's going to allocate those 10 or 20 points. And that could be in support of a much wider range of transformation related goals. So they could prefer women, youth, disabled persons, rural enterprises. There's a whole range of specific goals that they can now apply, not just BEE status. So that's opened up the procurement landscape considerably. And then finally, just to note that there is in the making a public procurement statute. It was published for public comment in 2020, and it's still going through the process. We expect it to hit Parliament this year, but we have been waiting a while, and the intention of that statute is to rewrite the whole of procurement law in accordance with the constitutional provisions that Yana went through, but to consolidate it all into one statute so that you won't have to have regard to all of these statutes that she went through. But yeah, we hold our breaths on that. Okay, thank you very much. Back to Jess, I think, for a farewell.
Thanks, Pippa. Thanks very much. And thank you for that very illuminating discussion and taking us through what looks like quite a labyrinth of regulation and a risk to bear in mind, as you pointed out towards the end of the presentation, for anyone contracting with a public entity or a state-owned enterprise or corporation, as you said. So thank you very much to both you and Yana for sharing your expertise with us today. And just a reminder to our participants, you will get an email within a day or two of this presentation where we will share with you the slides from the presentation and also the contact details of both Pippa and Yana if you'd like to get in touch with them. Thank you to those who did add comments. There were some comments that we didn't get a chance to address, and Pippa and Yana will come back to you on that if you added a comment. And finally, just a reminder that there are still further masterclasses in the series. There's another one tomorrow at 12 o'clock, where our panelists will be unpacking some emerging risks for pension fund trustees and their service providers. So it's not too late to register for that if you'd like to join us. And then you can also have a look at the lineup as we play out for the upcoming masterclasses next week. Thanks very much, and we'll see you again soon. Goodbye.